What starts as polite banter quickly turns into a masterclass on constitutional limits, judicial power, and the Second Amendment. With humor, sharp questions, and a perfectly timed bazooka hypothetical, this Senate exchange pulls back the curtain on how far rights really go, and who decides where the line is drawn.
Mr. Davis, did I hear Senator Cruz correctly say that you were a James Kent Scholar at Columbia, like Ms. St. John?
Yes, I'm in good company with Ms. St. John.
Okay. All right, so you were chief counsel to Senator Cruz.
Yes, Senator.
Senator Cruz is a pretty able lawyer himself. That must have been an interesting job.
I've had the privilege of working for multiple bosses who were phenomenal lawyers. Senator Cruz is the utmost lawyer as a Supreme Court practitioner. He was phenomenal, and I've had also the pleasure to work with many other attorneys. The judges for whom I clerked were both fantastic. So I've had a lot of great mentors and examples throughout my life and career.
In your job, were you around Senator Cruz a lot?
Yes, Senator.
Okay. We talk a lot about heroes in America, don't we?
Yes, Senator.
People who tolerate Senator Cruz on a daily basis are the real heroes, aren't they?
Senator, I have nothing but positive things to say about working for Senator Cruz. He was a phenomenal boss, and I just loved the experience.
Senator Cruz is my friend, man. I realize that's a questionable life choice, but he's my friend. Judge Wolf, you went to Baylor.
Yes, Senator.
We at LSU hired away your women's basketball coach, didn't we?
Coach Mulkey.
You understand we're not giving her back.
I understand.
Okay. Ms. St. John, what's a universal injunction?
Universal injunction refers to an injunction that applies universally beyond the parties to the case.
The Supreme Court has recently had something to say about universal injunctions, has it not?
Yes, Senator.
What did the Supreme Court instruct us?
Well, in Trump v. Casa, the Supreme Court held that universal injunctions are disfavored and courts are limited to awarding complete relief as to the parties before the court.
Did the Supreme Court talk about class actions in its opinions?
No, Senator, not directly that I recall.
Okay. Do you think one of the arguments, as I understand it, for universal injunctions, well, it's both an argument for and against, but that it impacts more than just the plaintiffs before the court. Is that correct?
Yes, Senator.
I've heard the argument made that a substitute, some would argue a more efficient substitute for universal injunctions would be a class action lawsuit. What do you think about that?
You know, a class action does allow relief beyond the named representative plaintiff. The class actions have a lot of additional safeguards set forth in Rule 23. And so, it does allow large groups of plaintiffs to come together in one case in a way that may not be, to seek relief in a way that bilateral litigation may not allow, but it does have additional protections.
Okay. Let me go back to Mr. Davis. Since we have our ATF nominee in front of us today, I thought I'd ask you a little bit about our Second Amendment. I want to buy a bazooka, and I found a good deal on one in Europe. Can I buy it and own it and use it here in America?
Senator, I believe that falls under prohibitions in the National Firearms Act, but let me speak more generally, because I think that's right, but let me speak more generally to the Second Amendment question, which I believe is what you're getting at. There is a fundamental right enshrined in the Second Amendment to keep and bear arms.
Right.
And the Supreme Court has said in Heller, written by Justice Scalia, that is a personal right. It's not a right that is tied to being in a militia. It is a personal right that includes for defense. The Supreme Court has since elaborated on that doctrine, including in Bruin and most recently in Rahimi. It is made clear that the test for Second Amendment rights is whether the right falls within the text, history, and tradition of this country. And so I would need to look specifically at whether a bazooka or a weapon analogous to it would fall under the protection of the Second Amendment using that test, if I were so lucky as to be confirmed.
Well, under Heller and Bruin, do I have unfettered discretion to own any kind of firearm that I want to?
There are certain exceptions that are listed within the decision in Heller. And for example, machine guns fall under the National Firearms Act. So there are certain exceptions to what arms can be owned. But again, I would go back to the text, history, and tradition test if a case were to come before me as a judge that was asking that question.
Okay. I'm sorry I didn't get to ask everybody questions. Thank you, Mr. Chairman.
The hearing opens with lighthearted praise and friendly jabs, but it doesn't stay casual for long. As the discussion shifts to universal injunctions, the tone sharpens. The witness explains that these sweeping court orders, binding even non-parties, are increasingly disfavored by the Supreme Court, which has emphasized restraint and party-specific relief instead. That leads to a deeper question. If courts shouldn't issue universal injunctions, what's the alternative? The answer points to class actions, a structured, rule-bound way to extend relief while maintaining procedural safeguards. It's a quiet but important distinction about judicial power and limits. Then comes the moment everyone remembers, the Second Amendment. With a tongue-in-cheek question about buying a bazooka in Europe, the senator forces a serious legal point. The response walks through Heller, Bruin, and the modern text, history, and tradition test, clarifying that while the right to bear arms is fundamental, it is not unlimited. Some weapons fall outside constitutional protection, and judges must rely on history, not personal preference. It's law, civics, and humor colliding, exactly what congressional hearings do best. Behind the jokes is a serious reminder. Rights matter, limits matter, and how judges interpret the Constitution shapes real life. This is why these hearings matter and why every word counts.